The debates around what kids are learning in school can get, well, pretty intense sometimes.
Definitely. And recently, one has landed squarely in the lap of the Supreme Court.
Right, this case out of Montgomery County, Maryland. And the core question seems to be, should parents have the right to opt their young children out?
Exactly. Out of lessons involving LGBTQ+ themes, specifically those presented in certain storybooks.
So today, we're doing a deep dive into this. We're relying mainly on an article from Newsbreak to sort of unpack this whole legal battle.
Yeah, it's a real intersection, isn't it? Parental rights, school curriculum, religious freedom, it's all colliding here.
Okay, so let's get specific. What sparked this? It was a set of storybooks, right?
That's right. Books added to the language arts curriculum, and we're
Mhm.
talking young kids here, pre-K through 5th grade.
And these weren't just optional reading, they are part of the lessons.
Correct. Books like, let me see, Pride Puppy, Love, Violet, Uncle Bobby's Wedding.
Born Ready, Prince and Knight, Intersection Allies, and What Are Your Words? That's the list from the article.
Yeah, quite a few. And it's worth looking a bit closer at, what's actually in some of them to see why they became focal points.
Okay, like Pride Puppy. What's the deal with that one?
Well, it's described as an alphabet book set during a pride parade. Apparently, it includes images of drag queens, people in leather, that kind of thing.
Hmm. And the article mentioned it's actually been removed from the curriculum now.
It has, yes. Though it seems it's still available in school libraries, just not used in lessons anymore.
Interesting. And Love Violet.
That one sounds pretty straightforward, a story about a young girl who gets a crush on another girl in her class.
Okay. And Prince and Knight. Sounds like a fairy tale twist.
It is. Described as two princes falling in love, fighting a dragon together, and getting married.
Then you have others like Intersection Allies that one asks kids about their pronouns.
Yes, directly engages them on that. And what are your words?
Apparently tells kids pronouns can change,
Yeah.
like the weather.
Okay, so that's the content. What about the timeline? How did this escalate? Well, the district added these books back in 2022, and crucially at first, they did give parents notice.
Notice and an opt-out option.
Exactly. Parents were notified and could choose to have their child excused from those specific lessons.
But then that policy changed.
It did. The district got rid of the notice and the opt-out.
Why? What was their reasoning?
They cited a few things. One was that managing all the opt-out requests was becoming difficult administratively.
Like practically hard to handle in the classroom.
Apparently. They also mentioned it led to more kids being absent for those lessons.
Okay. Anything else?
Yes, and this seems pretty significant. They were concerned that allowing opt-outs could stigmatize students or families who actually identified with the themes in the books.
So trying to avoid making certain kids feel singled out.
That seems to be the idea. But, this administrative point raises a question.
Which is?
Well, how do schools balance being inclusive with respecting different parental values without creating these huge logistical hurdles? It's tricky.
It definitely sounds like it. So who are the parents bringing this case?
The lead plaintiffs mentioned are Tamer Mahmood and Enos Barakat, a Muslim couple. Their child is in elementary school there.
And it's not just one religious group.
No, the article makes a point of saying other plaintiffs are Catholic, Ukrainian Orthodox. It's a diverse group of parents.
So their concern isn't tied to just one specific faith.
Right. It underlines that the concerns cross different religious backgrounds.
And what's their core argument? What are they saying through their lawyers, the Beckett Fund?
They're essentially arguing that these books are, 1, age inappropriate for young kids.
Okay.
2, that they could be spiritually and emotionally damaging. And 3, that the content is fundamentally inconsistent with their religious beliefs.
So a direct conflict between the school's materials and their faith.
That's the heart of their claim. It's about this clash between what the school presents and what they believe is right for their children's upbringing.
Now, jumping to the Supreme Court arguments, Justice Amy Coney Barrett had a question about this, didn't she?
She did. She raised the point about whether the school was just exposing kids to ideas or if it was actually presenting a specific viewpoint as, quote, the right view of the world.
Like teaching 2 + 2 = 4 versus teaching a specific moral or social view.
Exactly that comparison. Is the school being neutral or is it advocating for a particular perspective? That's the crux of her question.
But there was another perspective from the bench too, right? From Justice Ketanji Brown Jackson.
Yes. She brought up the idea that, well, if parents disagree strongly with the public school curriculum, they do have the choice to seek alternatives.
Like private school or homeschooling.
Precisely. And the article notes that some of the plaintiffs in this very case have actually made that choice, pulled their kids out of public school.
But that's not always a practical option for everyone, is it?
No, absolutely not. Changing schools, homeschooling, that can involve significant costs, logistical challenges. It's just not feasible for many families.
And it doesn't really solve the bigger question about what's taught in public schools generally.
Exactly. It's also worth mentioning, just for balance, that there was support for the school system's position, too.
Oh. Yeah.
Yeah, legal scholars Eugene Volokh and Justin Driver filed an amicus brief siding with the school district. So there are strong legal arguments on that side as well.
Okay. Now, let's circle back to the pronoun issue, because Intersection Allies touches on that directly.
Yeah.
There was a point made by Megan McArdle in the Washington Post.
Yes, that was an interesting take. She pointed out that while it's true some languages don't have gendered pronouns, it's sort of a leap to then suggest that sex or gender isn't significant in those cultures.
So simplifying it too much for kids.
That's the concern. Her worry was that presenting pronoun usage this way might give children a maybe misleading picture, especially about LGBTQ plus rights or realities in other parts of the world.
Like her example about Ghana.
Right, where the cultural context and legal situation around LGBTQ plus issues are very different, and just talking about pronouns might not capture that complexity at all.
It highlights how tricky it is to teach these complex social issues, especially to young children.
Definitely. Requires a lot of nuance.
So where does this leave us with the Supreme Court case itself? What's the precise legal question they have to answer?
Fundamentally, it's about the First Amendment's free exercise clause. Does the school board's policy, getting rid of the opt-out for these books, place an unconstitutional burden on the parents' right to practice their religion freely?
A burden on their religious rights.
Yes. Is the government, in this case the school board, interfering too much with their religious practice by requiring their kids to participate in these lessons?
And what are the possible outcomes? What could the court decide?
Well, broadly, two paths mentioned. They could rule directly on that constitutional question, yes, it is, or no, it isn't an unconstitutional burden, or they could send the case back down to the lower courts, maybe with specific instructions or standards to apply for further review.
Either way, the decision could have pretty big ripple effects for schools everywhere.
Oh, absolutely. Huge implications nationwide for how schools handle sensitive topics and parental rights.
We should also touch on the practical side, again, the teachers. The article mentioned they found managing the opt-outs difficult.
Some teachers did report that, yes, that having a lot of kids opting out made classroom management harder.
Okay, but there's a flip side to that argument, isn't there?
There is. The counterargument is, well, should administrative ease automatically override what parents see as fundamental rights, especially religious ones?
And couldn't a high number of opt-outs also signal something else?
Exactly. It could be interpreted as a sign that maybe these particular lessons aren't actually that popular or supported by a significant portion of the parent community. It's complex.
It really is. So stepping back, the big picture here is this constant tension.
Right, between wanting inclusive education for everyone.
And respecting parental rights and deeply held religious beliefs.
Especially when you're talking about elementary school kids and what they encounter in the curriculum, it's a tough balance to strike.
And the Supreme Court's decision, expected in June, is going to be really pivotal.
No doubt. It will likely set a major precedent for how school districts across the U.S. have to navigate these waters going forward.
So thinking about everything we've discussed, all the different arguments, the legal points, the deeply held beliefs on both sides, it really makes you wonder.
What stands out most?
Yeah, what do you, listening to this, see as the most critical thing to consider when we're trying to navigate these kinds of debates in such a diverse society?
And maybe, what are the potential long-term impacts? Not just legally, but socially, educationally.
Yeah.
No matter which way the court rules.
Definitely a lot to think about there.